where, remember, several powers of the ED under the PMLA, in fact, were challenged. These are powers for search, arrest, seizure, investigation and attachment of properties. The Apex Court has upheld the rights of the Enforcement Directorate now when it comes to arrest, seizure, investigation and attachment of proceeds of offence under PMLA. Remember, the petitioners had been arguing, Nalini, that some of these provisions, something that Gaurav Bhatia also spoke about, was in violation of the fundamental rights of those who were being questioned and grilled by the ED, isn't it?
Well, yes, Neha, and a very important and interesting provision in all of this, I was in challenge before the Supreme Court, was Section 45 of the PMLA, which specifically talks about grant of bail. Now, what Section 45 does is it imposes twin conditions before bail can be granted to any accused under the PMLA. These twin conditions are, one, that there should be reasonable grounds to believe that the accused is not guilty of committing the offence, and the second is that while he is out on bail, he is not likely to commit any offence in the future. So what the petitioners had stated before the Supreme Court is that these conditions for bail are extremely stringent, and at the time of bail it is not possible to ascertain as to whether or not an accused is guilty of the offence or not guilty of the offence. But surprisingly, the Supreme Court has also upheld these twin conditions for bail under Section 45, and they have said that the conditions for bail that have been put in place in the PMLA are in fact reasonable, keeping in mind the procedure of the PMLA and the powers of the ED, which means that there is no relaxation for even grant of bail under the PMLA. This is something that the Supreme Court has spoken about time and again, about how bail is the rule and jail is the exception, and how liberty of an individual must be paramount. But despite that, through this judgment, the Supreme Court has not struck down any of these conditions, even though the petitioners time and again claimed that they were extremely unreasonable and violative of the constitutional rights of the petitioners, including that of liberty. But these two now have been upheld by the Supreme Court. The Supreme Court also said that ED officers are not equivalent to police officers. And the reason why that's important, Sneha, is because during any course of investigation being done by a police officer, a confession that is made before him by an accused is not admissible as evidence in court. But now with the Supreme Court saying that the ED officers are in fact not police officers or not equivalent of police officers, that means that any confession made before an ED official can in fact be admissible in court as evidence. So this is a massive setback to all of the petitioners, all of the opposition party leaders who were trying to get these provisions struck down. It comes as a massive setback to them, and at the same time a massive boost for the investigating agency as well as the central government to go ahead and investigate further cases of money laundering against opposition leaders and other individuals.